Okay, I believe we are live. Okay, this is Delegate Charlotte Crutchfield, the chair of the Family and Juvenile Law Subcommittee of Judiciary Committee. It's Wednesday and it's about 1:10, and we're going to get started on our subcommittee meeting. Our first bill up is HB 681, and I want to just make sure I'm just gonna tell you a brief summary, but correct me, Delegate Tolles, if you will. HB 681 provides a factor or a rationale that people who earn 250% of the federal poverty line, which is about $38,000 or less, will no longer have their driver's license suspended for child support arrearage. That is my understanding. Is that your understanding, Delegate Tolles, as well?
Yes, Madam Chair.
Okay, great. All right, committee, we've had a hearing on this one. Does anybody have questions? We have DHS present as well as one of the lobbyists to assist us as well. And go ahead, Delegate Valentine, with your question.
My only question for the 250 is that's if they're not voluntarily making themselves in that manner. Is that correct? Like voluntarily impoverishing themselves. So I can't make a scenario where I make that 30,000 a year voluntarily or do other means so that I can get this benefit. Is that correct?
I see heads nodding, so I believe that is correct. Unless Delegate Tolles, did you want to comment?
Can you just reframe your question? I don't understand, but if the attorney say then that's the case, that's the case. But can you reframe?
He's asking whether people who voluntarily impoverish themselves, meaning that they have done something out of the norm, right, to impoverish themselves, would they still be eligible for this? And everybody's nodding their head to say no. You have to. This has to be clearly your income is less than the 38,000.
Yes, and and I wanted to understand better because I thought I heard something weird. Yeah, I don't think anybody would impoverish themselves intentionally, or if it is, it's a very minute, like special group of people, but I don't think anyone would do that, voluntarily.
I was thinking along the lines of someone who is remarried, their spouse has a very well-paying job, and maybe they took a job that say they were making 60,000 a year. Well, I can take a job for under this threshold, but my wife's income could make up the difference, and then I wouldn't have to pay child support. That's the scenario I'm thinking. So they would voluntarily impoverish themselves under that scenario.
I mean, like I said, I wouldn't use that word. That's a hypothetical. We can, find hypotheticals in so many instances, particularly in this type of, with child support, delegate. But I don't think anybody would voluntarily, whether it's, maybe staying home to watch the kids while the wife work because she makes a huge amount of money or something. I'm not sure, but I think to the bill, it just, when you go through the necessary factors to prove that you are beneath that 250% poverty level, then you would be included in this bill.
Okay.
Thank
All
you.
right, Delegate
Thank you.
Bartlett, you have a question as well.
Yes, thank you, Madam Chair. And to touch on the voluntary impoverishment, the court looks very unfavorably at voluntarily impoverishment. And it is something that comes in no matter what your income is, if they feel that that's what you're doing. So it's on the other side to prove that that is what you're doing. So just to let you know, just to answer that question, Delegate Valentin, not to answer the question, but to provide my input and my empirical understanding. The other thing is I wanted to talk about on the fiscal note, and this is a question, I guess, for DHS. You said they're here?
Yes, we got several representatives, it looks like, from DHS.
Okay, so I just need one person to answer this one question, and that is, or address on page 3 of the fiscal note under Department of Human Services, DHS, state and local fiscal effect. It says that DHS advises that you're going to need 29 caseworkers, however, at a cost of $2 million, but DLS disagrees that you need 29. Do you want to address that?
Good afternoon. My name is Jarnis Johnson, and I am the Executive Director for the Child Support Administration. And I'm going to ask my Director of Policy to answer that question. So Janica, if you're on the call, could you please respond?
Yes, I am. Thank you, Jarnis. And thank you for the opportunity to again be able to provide some clarity. When it comes to the calculation of income, again, this is something that typically isn't done within child support unless there is a request for a modification. We must go through all the proper channels to gather the same information, income information that the courts would consider. Based on that, then we proceed forward with kind of storing that income information for the purposes of modifications. When it comes to our daily tasks, this is another aspect of child support that we typically don't do for every customer every day. So when we're looking at measuring that 250%, it will be a new task for our workers. It will be certainly something that will require research, investigation, and again, compelling that kind of record and information from these individuals to ensure that if we can get their income proven, that we're doing the right next step, whether that be excluding them from the driver's license suspension process or being sure that we can move forward. So this is just another aspect onto our workers, another additional task for them every day. So, pardon me. So I believe that's why those additional, just one caseworker for each jurisdiction, 2 for the metros were added.
Okay, but as Delegate Bartlett mentioned, our legislative services folks are saying they didn't think that was necessary, that you guys would be able to handle it without that many new workers added. So I know it's a new calculation, but I also understand you guys already do calculations. Isn't that correct?
We do, but not for every customer. It's only upon request for that 3-year review. That's when that calculation is typically done.
Okay. Okay. All right, go ahead, Delegate Tolles. You have a question.
Yes, thank you, Madam Chair. But you already have caseworkers that do this now, is that correct?
I can speak to that, Jenna. We have caseworkers that run the guidelines, but not look for the 250% of the poverty level. I believe what this would require, in addition to the establishment portion, is in order to determine whether or not the non-custodial parent would meet the requirement for exemption under the 250% when they qualify for a possible license suspension. This is in addition to our guidelines. So we don't currently determine the 250% of the federal poverty level when it comes to driver's license suspension. It's if they are not in compliance with the current child support orders. So this will be in addition to what the caseworkers are already required to perform.
So a couple of follow-up, Madam Chair.
Yeah, go ahead.
Thank you. So just yes or no, you already have caseworkers that work on child support, is that correct?
We have caseworkers that are required to maintain our child support caseloads, yes.
Okay. And is it correct that you all do have a bill that is asking to do this as well? That will make, you all have a bill in floating around judiciary that will ask us, has the same type of, policy in the bill that you have?
It does, in a sense. I will explain a little bit about the difference.
No, it was just a simple question. Do you have that? I'm sorry, I'm trying to convince.
Yeah, understand. Yes or no? Upon submission of the income information.
Right.
So that would not be on every case. So that's why I was saying that's a yes and a no. If the non-custodial parent provides the income information, then we will determine the 250%. Whereas, go ahead.
I know what this bill does because it's automatic, and
Okay.
we had a hearing, so I don't want to rehear the
Okay.
case. Just in the essence of time and out of respect for the committee, I don't want to rehear the case. And the simple question is, and my point I'm making is that in a bill that you have floating, you have this same policy that you are intending to deal with individuals that are under the 250% poverty level. I do recognize this is automatic, but the point is that you are looking to do this policy as well. So there obviously was, you know, some staff there that can handle this if you already looking to do this policy in your bill. That's all I was going to say. So I just wanted to kind of put that out there for the record. So
Right, and I think I want to add to that because again, going back to my previous question, which is that you already are in the business of calculating child support, correct? So
Yes, we
that
are.
would mean that you would have people and or software that can be manipulated to turn out this particular information on every obligor if we need it. I would think you already have something in place and it's a matter of software maybe or something else that has to be done, but I wouldn't think individual caseworkers necessarily are doing this each time. I mean, okay,
Yeah,
so you
so
think for every time you calculate child support, some individual sits with a pen and paper and calculates it out?
They
So-
receive, hold on a second, they receive the income information from the parties. And yes, there is a guidelines, a calculator that is built within our computer system, but that requires a worker to go in and input that data into the guidelines worksheet. So yes, we do it, but it's not a manual, but we have to have the income information from the parties in order to do
So
that.
what's the difference here? Because you would get income information as well. I guess I'm a little confused.
For
I mean,
the establishment portion, Delegate Crutchfield, when we establish a support order, it is required that we have the income of both parents. However, for the driver's license suspension, this is on the back end. This is on the enforcement portion of it, that we do not get the income information for the enforcement up front unless we request it. And that's why in our bill, we request that information so that we can determine whether or not the non-custodial parent meets the 250% of the poverty level. But if that person does not submit that information, then there's no way for us to know whether or not they meet the threshold for the 250%.
okay. So you're saying, okay, let me make sure I got this. So you're saying that up front you need the information, which, okay. I
For
understand that.
establishment, yes.
Okay, for establishment of whatever the 250%
Support order.
is, right? And then that way, you then have the information, it can go directly to MVA and you can explain, or you can determine right then and there that that person meets the guidelines, right? Is that what you're saying through what you're suggesting? I mean, kind of tell me what you're suggesting, because you're suggesting front end, you get the income information, you make the determination, and then what happens?
So after the order is established, that could be years ago. So now we're in the enforcement process for the non-custodial parent. The non-custodial parent has not made a payment or meets the non-compliance. Then what we will do is we will send out a notice to that non-custodial parent to say you are in jeopardy of possibly being referred to the MVA for possible license suspension. The way that our bill is written, they can request an investigation because one of the bases would be the 250% of the poverty level. Then when they provide that income information to us, that's when we will determine whether or not they meet the 250% of the poverty level. If they do not provide that information. It's not an automatic, because that information from the most recent order or whatever could be 10 years old or 5 years old and so forth and so on. So we don't have current income information unless the non-custodial parent provides that to us, because it has to be under the current federal poverty level. So that's the crux of the bill. It's to get the notice to the non-custodial parent, letting that person know that they are in jeopardy. They are not suspended at that time. Please provide information to us. If there's a hardship, please contact your local office to determine whether or not there's a hardship.
So I'm going to interrupt you just for a minute, because it sounds like you're talking about a different or new assessment. You're talking about something a little different. But I'll go ahead to Delegate Bartlett real quick. Go ahead, Delegate Bartlett.
Madam.
Yeah, I see
Thank
you, but
Madam Chair.
let me go to Delegate Bartlett real quick. Go
Thank
ahead.
you, Madam Chair. My point is, I was going to ask Ms. Johnson, she was explaining the process currently and also what the process could be. So there is some level of, there is some threshold now, correct? Isn't there something that, I mean, we don't take money from someone who's not, we don't get, isn't there a guideline now that exists as to determination to help you all in determination of I'm trying to use the right terminology, but you all have guidelines now as to whether or not a person is, first, one, meeting their child support requirements, and two, what their income is at this particular time that they are now no longer, that they are not meeting their child support requirements. There are guidelines that exist, right?
There are, I'm gonna try to answer without taking up too much time, to be considerate of everyone's time. Our current process right now is that an order is established. Now they're in the collection phase as far as paying their child support. If a person is 2 times the support ordered amount, and I may ask Jenna to,
I guess,
because
Ms. Johnson, I just want to tell you where I'm going with my question. I'm sorry to interrupt you, but in the interest of
That's
time,
okay.
and I'm going to pull up the section myself, but I wanted to know now, you must make a determination. There is some impoverishment guidelines now, right?
There are hardship rules, yes. That
Yes.
we
Okay,
use.
hardship,
We have
that's the
guidelines
word I
in
want.
our policy,
Okay,
yes.
so there are hardship rules that exist now. So there is a
Yes.
determination that gets made now based on whatever is presented, whatever you all review based on hardship.
Yes, that is correct.
Isn't it correct that it is your anticipation or your department's anticipation that if this bill were to pass, that it would result in more, but we in fact don't actually know because of the fact that we don't have the 250% federal poverty now, right?
That is correct. We don't have
Okay.
that income, correct.
Right. So what we do have is there is a hardship, and at this particular time, those individuals that review the hardship request or whatever it is, exist. They do the work, they review whatever documentation is in. I guess what our question is, why is it estimated that it would be so high of 29 individuals when there is a level of review that is being done when there is a hardship request? How do you know that it's going to be so much more, so many more cases? I guess that's where that's
Because
the
not
question.
because not everyone requests an investigation under the hardship. Whereas the other, if you look at the back end on the other bill, not the department's bill, it requires you to do that for everyone up front before you can even send the notice. Ours is we send the notice, and if they then request it, that's when we would do the investigation investigation to determine whether or not they met the hardship under our guidelines. So
because a person is saying, I make less than 250% of the federal poverty guidelines, that's something that I would, let's say I'm the obligor, that's something I would submit voluntarily. I would say I shouldn't have to pay child support because I fall within this section, right?
And they have requested it. Yes, that's
Yes,
correct.
so that's my point. There's no way to anticipate how many people are going to do that at this stage yet, because it's something that has never been done. We don't know that. You would have to do it at the front end if somebody requested or somebody claims it, but it's not an automatic claim. And that's the part I think I'm getting confused about, because it's an automatic action that you all have to take, but it's not an automatic claim that they're below the 250% guideline.
And I'm going to go to Delegate Tolles real quick, because I think you've got language in your bill that also talks about establishing income orders. Do you want to talk to that, or would you like to have Chris Dews do that for you?
Well, at first I wanted to touch on, I wanted us to state on this bill. Was kind of
Yes,
hoping that
we're on this bill. That's
yeah,
what we're
before,
on.
okay, so that, and so I want to
Okay.
thank Vice Chair Bartlett, who touched on some of the things I was going to touch on, but also that we stick to this bill. And the difference between this bill is and there, this bill is, I want to stick to the fact that this is automatic. So having to send something in and you all figuring out whether this person meets this threshold is not with this, but it's automatic. I don't agree that, folks are already in a hardship. So to have to call, get an appointment, find a way to get to you for you to write it by hand, that's not what this bill does. It's saying it's
That is correct.
automatic.
That is not what this bill does. You are absolutely correct.
So
But
thank you.
yeah, she was just describing what they do now. But the
Right.
point is also that income is, they're going to know the income of the person up front. Chris Dews, you want to talk to that a little bit? So there's not going to be an issue. I mean, that's what I guess I'm getting at, is I don't understand why there would be this thought that you need more people when they're already going to get the income up front and be able to do it. But anyway, I'll let you talk to it, Chris.
And I will be very brief. I'll just say that, yes, within the bill itself, there is language that says that the child support guidelines, which is the calculation, will be sent, once that order is established, will be sent directly to the Child Support Administration. It also says, and this is page 4, line 19 through 24, that that to determine the income of the obligor, that if you do need to do extra calculations, that income, the best way to start is to use the most recent child support order that it's already been established. So we are in the same boat that that new staff should not be needed, not to the level of 29. But I will say this, because this was also mentioned at the subcommittee hearing, that DHS is generally looking to add new staffers. We just generally don't believe that it would be necessary to the level of $2 million for this piece of legislation. But yes, that income information, there's ways to get it without having to do a lot of extra heavy lifting and to keep the process automated. The last thing I was going, you know what? I think I'll stop there.
Okay. Delegate Kaufman, did you have a quick question? You turn off your, yeah, there you go.
So my question is, and then when the time is right, I would like to move favorable. But my question is, there's to the CSA, or what accounts for the differences? Because you guys are looking at the same set of facts, and the Department of Legislative Services, who's sort of like our in-house experts, says you don't need that many people. And then, you're very earnestly today saying, oh, yes, we do. And it'll be, cumbersome and da, 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 da. So what accounts for the discrepancy within two smart people? Because you're looking at the same set of facts and you came up with a very different conclusion.
Well, it sounds like, Delegate Kaufman, that they're saying that they believe that they're going to have to do more calculations coming in. But as you heard from Delegate Bartlett's discussion as well, it didn't sound like that's really feasible because they really don't know what they're going to be ultimately dealing with.
Yeah, I mean,
So I think that's really the crust of what's going on, is that, they're not sure of what exactly they're dealing with, but they're estimating based on, and I don't know what that real information is, that they think they're going to need more people because they think they're going to have to do more calculating. But if they've already got software, you can input the data in, it just doesn't seem like that would be something that would be necessary.
it doesn't seem like it to me either. I think a lot of it is anticipatory anxiety, but that's just my.
Yeah, and I think that's what we've got going on here, and we understand, But anyway, I think we are ready to decide here what we're going to do with this bill.
Move favorable.
Okay, do I have a second?
Second.
Okay. All right, so we're going to go ahead and do a roll call vote on the bill. All right, Delegate Bartlett,
Yes.
Delegate Boucher,
Yes, ma'am.
okay, Delegate Kaufman,
Yes.
Delegate Pastor, I don't see her. Okay. Delegate Sample Hughes,
Yes.
okay, Delegate Simpson,
Yes.
Delegate Taylor,
Yes.
Delegate Tomlinson,
Yes.
Delegate Valentine,
Yes.
and I'm a yes as well. Okay. We have passed it out of our subcommittee. All right. Thank you very much, folks from DHS and Mr. Dews for being here for us. We appreciate it. Thank you. You're
Madam Chair, I
excused,
just
and
wanna thank-
Delegate Tolles as well.
I just want to thank you and the committee for getting it out and for the support. So I just want to thank you all, colleagues. And
All right. We'll see you at 3 o'clock.
I'll see you at 3 o'clock. Thank you. I'm gonna head over to my bill hearing now. Thank you.
You're
Bye-bye.
welcome.
Bye.
So now we're going to hear our next bill, which is HB 366. And do we have Delegate Embry in the waiting room? See, there she's coming on board. Okay, and there should be actually somebody from the Attorney General's office. I do have Renee Joy and Rhea Harris, and somebody from the OPD's office. Okay, yep. There's Elizabeth Hillard. Okay. Okay, great. All right, Delegate Embry, are you there? Let's see. She looks like she's still coming on. Okay.
And I was gonna say, Madam Chair, Renee Joy is coming on. She's the deputy chief for
Okay.
the ID.
Okay, great. All right, I'm just waiting for Delegate Embry. She doesn't seem like she's quite in yet. There she is. Delegate Embry. Let's see. Can you hear me, Delegate Embry?
It still says
Yes.
connected.
I'm sorry.
Okay.
Took me a second. Thank you.
We're ready for you.
I appreciate it.
So could you just give us like a really brief summary of what your bill does?
Absolutely. And I'm glad to see there's some representation from the Attorney General's office so they can add
Yes.
anything I miss. Thank you guys for being here. So the purpose of this bill, and it is pared down from last year in response to concerns raised by the Public Defender's Office. When the Independent Investigation Division was created as part of a larger package of police reform, one of the purposes was to provide transparency to the public so that they would understand what happened when there was a police-involved fatality or serious injury, and also how it was being investigated. And so the Attorney General's office, sometimes the victims are juveniles or kids, and the laws around confidentiality of police records for juveniles is absolute. And so they are committed to releasing certain information fairly quickly after one of these incidents happens, and they include the name of the person who was hurt or killed. And with adults, that's of course not an issue, but with kids, it is. And so this bill is an attempt to find a solution to that. And so it allows it only with the permission of the parent or guardian. I understand the public defender still has concerns, as does law enforcement. So I have not come up with a solution. I don't know if anyone from the Office of the Attorney General has any compromise or, ways to address the concerns, but that is what the bill does. Thank you.
Okay. Well, I think I'm going to just start off with a couple of questions. And it is really probably to the AG's office, and that is, why is it so important to have the name of the child in a circumstance like this?
Want to take that, Renee?
Sure. Good afternoon. I appreciate you allowing me to be on to answer some of your questions. We believe, can you guys hear me? I think I just
Yes.
broke.
Yes.
You can, okay.
Uh-huh.
We believe, we were founded on the premise of transparency, and we do really like to be transparent. We think it's important because it gives the public the full picture of exactly what happened. A lot of times, for example, or not a lot of times, because we haven't had that many cases, thank God, but there have been times where the family will go ahead and publish the name, whether it via social media, whether it's in the newspaper or something of that nature, and our office is not even in a position to confirm what the family is saying, unfortunately. So we believe that it is important for us to convey all of this information for the public. We believe that there is a big demand by the public for increased transparency in these cases. There actually are 2 different times where we can release that name. We do a public release of all the names of involved parties 2 days after an incident happens, and then several months later when we release our report would be another opportunity. So we have a lot of contact with the family over this time, and sometimes we want to be able to give the family the opportunity to release their names and for us to be able to confirm it.
But just to be clear, is the name and the age of the juvenile in the general area where they're from, not their address, not their pictures, none of that?
Okay,
That's
got
correct. Yeah, when
So-
we release name, age, and their city and state of residence.
Okay. So one of the things I guess I'm concerned about is that even though you're saying it's limited information, it sounds like 2 things are happening. It actually sounds like you're already working with the family, right? And the family probably has released the information. And then, I would assume you have a liaison that goes to the family and says, hey, we see this on social media. Is it okay for us now to move forward and release more publicly? I mean, does that happen?
No, if the family releases the name, we still will not release the name. We do not believe that the laws, the way they're written now, allow us to confirm that name and release it, even though the parents do. Because the way that we understand the law to read is that right now the parents cannot consent to the release of the juvenile's name. So we have to respect the way the law is written, and so therefore we will not confirm or we will not release the name, even though the family does.
Okay, because that's what I was thinking, that was one thing. The other thing I think I have a problem with is to me, it stigmatizes a family or child when you release that information. It also possibly points to where the family lives, if there's a problem with any kind of extenuating circumstances regarding a death, like if it is a death because of a shooting or some other related reason. I would be very concerned because you could still have family members who may be witnesses or who may be targets as a result of the name being exposed. Have you dealt with that issue before or thought about it at all?
We have not dealt with that issue. What I will say is that we don't publish any witnesses' names in our reports.
Understood, but
Okay.
I'm just saying that when you release the child in a
Right.
name, right, and the situation that occurred, then people can obviously assume certain things, like maybe the family member was in a house, or I mean anything, and suddenly that person becomes a witness, even though you have not identified them, but maybe there's some fear, there's, depends on where a crime happens and the general nature, and also, the circumstances, if you're in certain parts of certain areas of cities, counties, whatever, it's small enough that people would say or assume, okay, wait a minute, they could be a witness, or, which could create more problems. And I'm just saying, if you guys haven't experienced it, I was just curious, but that's the immediate thing that I kind of thought about. So,
But also too, that's why we put in there with the consent of the guardian or the parent.
understood, but that does not eliminate the witness thought or what the world around us thinks about certain people. So anyway, I'm going to let Delegate Bartlett go ahead. She has a question.
Hi, thank you, Madam Chair. I hope it's a question. I was gonna I just realized. So as it stands now, I guess this is for Renee or Rhea. Hi, Rhea, how are you? Could you currently, could the AG's office currently subpoena the court to allow you meaning the office of the AG, not to make this personal to either one of you, but to allow the office of the Attorney General to allow the publication of the names of the children? Could you do that by subpoena now?
Not sure that we
get,
can.
are you asking, could we pursue a court order to allow us to release the name?
Yes.
I think we could ask. We have not tried. We could ask, but just based on my, reading of pursuing a court order that is asking to release certain information, we would have to provide a very compelling or extenuating purpose of why we should be allowed to
Yeah. And
Mhm.
that's my problem with the bill. That's my problem with the bill. I think that we have done as a society, we have a strong public policy against releasing names for certain individuals, children, etc., on purpose. And there should be a very strong and compelling reason to go past that. So I'm probably going to be a no on this because of that reason. Because it has to be, I don't hear a compelling reason, especially when the family has the ability to change, to put it out there themselves. And so if you have a compelling reason, this is the time to share it. But I haven't heard that in the hearing or in the written or in the testimony.
Can I
So
just say
thank
this,
you.
that it would not be every juvenile involved. This would be the deceased juvenile. The juvenile would not be a witness because we would keep that name in the investigation.
Understood.
Okay,
Thank
I just
you.
wanted to point that out.
It's okay. Thank you. Understood what you're saying, but I think we're not talking about the juvenile as a witness. We're talking about just, again, the disclosure of the name, which could probably create more issues. But anyway, go ahead, Delegate Sample Hughes.
Thank you, Madam Chair. I'm trying to dig down deep and figure out still the benefit of this, but I did want to get clarity. If we were to pass the bill, you had mentioned that you can release the name 2 days after the incident happens, and then again months later after it has concluded. So if this bill were to pass, is that the practice? Like you would be able to release their name in 2 days or prior to the 2 days? I'm just trying to understand that part. And then there's just one other question I have for you.
Yeah, so the protocols, the way our protocols work is that we would release that information 2 days or 2 business days actually after an incident happened. If we didn't have the opportunity to get consent from the next of kin, we then would not release it at that point in time. And then the next time that comes along is when we issue our report of investigation and legal analysis, as you probably have seen on our website. That would be a second opportunity for us to regroup with the family and see if they would like to release the name at that point.
Now, the bill speaks to not only a deceased child, but it speaks about injury. So you would still be releasing the name of some child that was severely injured as well. So that's concerning for me. And then the last part, with the body camera footage, you said you can get release of that like 14 to 20 days later. So I don't really understand, I'd rather see the body camera footage like we have done with law enforcement. It's very transparent now, which I really appreciate, the accidents and things with fatalities. And we've been able to see that as a public. It's cut down a lot of the frustration that the public has had with law enforcement. But I guess what I'm trying to get at is that I still don't see the benefit because we're talking about severely injured child and we're also talking about a deceased child. What's the benefit at the end of the day? And that's the part that I'm kind of struggling with.
Okay, first of all, when the body camera video is released, you do not see the identity of the juvenile at all.
Okay.
And so we're not trying to get a parent, we're not trying to get authority to do that. We only investigate incidences when police are involved and the person is deceased or likely to be deceased because of serious bodily injury.
Understood.
So that's kind of how that wording gets in there.
Okay. All right,
Okay.
I'm going to go to
Thank you.
Delegate Valentine. Thank you, Delegate Sample Hughes. Sorry about cutting you off. Go ahead, Delegate Valentine.
Thank you, Madam Chair. And I'm going to echo some of my colleagues' points because I've read both the Chiefs and Sheriff's paper as well as the Public Defender's paper. And my concern is for these children as well. And we talked about consent, and I'm reading in the Public Defender's written testimony, do these parents in these moments that are so close to when these incidents occur, do they fully understand and appreciate just the scrutiny and the blame and the accusations that these children could be facing? I know they're deceased, but their family and who's there to protect these kids and their memories when they've had this horrific incident, whether it was justified or not. I just don't know if the benefit is there for these families. And that's my concern. And how you're dealing with that now at the OAG's office.
We have a victims coordinator who talks to the families. It's not the police department, it's not the investigators, it is the victim coordinator who talks to the family. And the family can give consent, not just at the time, they can give consent at any time throughout the process. So they don't have to do it at that point. They can think about it and do it later. So it's not like you got to make the decision now and that's the only time you can make the decision. So they get time to process what has happened and then make a decision.
2 weeks. I know you have timelines, 2 weeks, 3 weeks. What does that time look?
The whole process.
But does that then go back that they have the ability to do that themselves anyway? I think that was also noted in the public defender's report or testimony that they have that ability now.
It can get out.
Right.
But it's not like we can't confirm it. We can't say anything if they haven't given permission for us to say it, if this bill passes. If this bill does not pass, we still can't confirm at any time.
Again,
thank you.
Thank you.
Thank you. So Delegate Simpson, you have a question?
I have to put on my sound. Okay, so yes, I do. Thank you very, very much. I do understand the importance, and I absolutely, I'm usually the biggest fan club of Delegate Embry. So I really do appreciate that we need transparency. I do. And I agree that the public needs to know if a child has been injured or killed, by the police or even in any type of state institution whatsoever. But I don't think releasing the child's name is appropriate. And I don't think I agree. I'm going to echo Delegate Valentine's, is that he put it perfectly. I don't know that the parents really could fully understand what they are releasing or what they are agreeing to. I mean, I do think that we need greater transparency, and we do need to look at these cases, and the public needs to know, but not this. We need privacy too, and respect that privacy, particularly, and be very protective. I'm going to echo Delegate Bartlett's and our chair's comments about how important, it's equally important for us to protect those who can't protect themselves. And clearly the outcome shows they were unable to protect themselves. And so I can't in good conscience. I mean, maybe we can look at it a little further where we're just giving the age of a child and the gender of a child, or, you know, or some circumstances or some type of review information, but not the specifics like a name or the family.
Okay, thank you very much, Delegate.
I'm just sorry, it's storming out here.
Yeah, understood.
Trying to get everybody over the rain.
Yeah, it's okay. Understood, because yeah, it's storming here as well. Okay, so we're going to go on to Delegate Boucher. You have a question, Delegate?
I just wanted to state my summation on this bill. First of all, I love working with Delegate Embry. She's extremely intelligent. I also like working with Ms. Harris. It is so good to see you. You're so pleasant to see and engage.
Thank you.
I am looking at this running parallel with my opinion on parents not being able to waive the Miranda rights of a juvenile. So I'm kind of looking at this in a parallel fashion. If we believe that parents don't have a right to waive their child's Miranda rights to their Fifth and Sixth Amendment rights, we should not allow parents to disclose this information. And we all don't know the motives or how well of a parent someone is. So we have to side on the era of safety on this. And I'm trying to look at it that way. I don't want the parents to be able to disclose the names. And I'll just leave it at that. Thank you for all the work everyone's doing, and especially the debate and the dialogue going on this, because it's very, very important. Thank you, Chair.
Absolutely. And thank you very much. I think based on the discussion we've had here, that it's clear to me that we're not ready to make a decision on this bill right now, but do appreciate, you know, everyone being present, the AG's office, OPD's office, and we will take this up at another time. So again, thank you. And I think we're ready to adjourn because we've gotten through our two bills that we needed to do today. And do I have a request to adjourn? Do I hear
Move to adjourn.
All right, in a second, I think I heard. So thank you again. All right, great. Thank you again. And I will see you at our bill hearings. Bye now.
Bye.